Good afternoon and welcome everyone to another episode of Speaking Legally, where the legal meets the cultural. We're here with you on Wednesdays, 4 p.m. Eastern Standard Time, and we thank you for tuning in. We thank you for sharing your comments. Hey, Kevin, thanks for always being here. So we appreciate the fact that you tell us that this content has been helpful to you as you navigate this ever-changing world that we're living in. And it's always a pleasure to be joined by our legal experts. We have Royce Russell Esquire joining us today. Errol Pichardo Esquire is unavailable for today's show because, we're working with attorneys who are always doing and moving. And we're just grateful that we do have a chance today to get into some information that'll be helpful to you as you navigate and think about where the legal meets the cultural, someone in your family that might need help, or maybe you might need help. So you never know what you can learn when you join Speaking Legally. So make sure you share the broadcast and let others know about it. So before we go ahead with our show, good afternoon, Andrew. Great to see you as well. Let's get started with some greetings from our legal expert, Royce Russell Esquire. Over to you, Mr. Russell.
Hey, welcome everybody. Welcome to today's segment. Today's segment is going to be hopefully informative and educational. Usually we have some lead stories that go with the platform to kind of seal the deal, as I say. Take the legal, take the cultural, wrap it around a story and something that's happening in real time to be able to really cement the education part that we're trying to present to you today. And today is no different. Today is exactly no different. We know that we have the what I'm going to call the infamous trial in Atlanta of the American style new age lynching, where there's only one juror that is of color in a county where 26% of the people in that county is of color. And so that inspired me to talk about today bench trial, jury trial, mediation, and arbitration. What does it all mean? Um, what what are the advantages of one compared to the other? What should I be looking for? Where's the world moving to now that we have withstood and still fighting the COVID pandemic? And how are courts changing? And how is the presentation of law and the litigation of law changing, giving these four different ways of proceeding? So that's what we're doing today. I hope all of you are doing well. And whenever Dr. Grant says the mic is yours, Mr. Russell, I will take over.
The mic is yours. We're just showing a little. There's an article, and there are a couple articles that you can look up, but we're going to get into it: bench trial versus jury trial. So you're going to share with us some of those differences.
Right. And so one of the things that we see here when we talk about bench trial, jury trial, now this is happening in real time, folks. So someone is banging on my door. Yes, sir. Yes. Your father took everything. Okay, thank you. All right. So that was it. Can you imagine? See, now this is what you call a real time show. So that was a client that I just got through interviewing, and he thought he left his cell phone and his charger, but his dad took
Well,
it.
that's
So
what happens when we have live attorneys as legal experts.
that's right. But I'll never let you down. I'm here for the show. So as we see on our article here, bench trial versus jury trial, this is becoming something of importance. When we look at criminal justice reform and we look at reforming the court system, one of the things that we are looking at is bench trial versus jury trial. Um, there has been said in history that the wheels of justice move slowly, and there is a concern for that. We went through a pandemic, and if you thought that the wheels of justice was moving slowly before the pandemic, it is moving really slow now. And so, how do we advance that? What can we do to accelerate the backlog of cases that are in the system? And so, bench trial versus jury trial has become a hot topic. And as it says here, bench trial versus jury trial, what is the difference? So, let me explain. A jury trial encompasses the community, a jury of your peers, people that live in your county, live in your area, geographical area, that is going to hear the lawsuit. If it's a prosecution, they'll hear the prosecutor present his case, they'll hear defense counsel present their case to protect their client, and a decision will be made as to whether or not that person should be found guilty or not guilty. In a civil suit, we use the words liable versus not liable in place of guilty versus not guilty. Same type of concept. Juries of your peers, hopefully reflective of people that live in your community, will hear the lawsuit and then make a decision as to whether the party is liable for leaving the floor wet and not putting a sign that says floor is wet, be careful, or whether the person is not liable, the sign was there, but yet the plaintiff, the individual, still walked intentionally onto the wet spot and slipped and fell and hurt themselves. So that's what we're really dealing with. So when we look at the litigation that is going on in Atlanta right now, I believe the gentleman's name is Aubrey. I forgot his last name. That's what is missing me. I'm having a senior moment. But the gentleman that was
Ahmad
basically,
Arbery.
yeah, say that again.
Ahmad Arbery.
Ahmad Aubrey, right. And so when we look at that, we see that that is a jury trial and that there is one person of color that is on that trial that is presiding, that's supposed to be reflective of the community. So some would say that that is not a jury of your peers, but that is what we call a jury trial. Facts are presented, jurors make a decision. Versus a bench trial. A bench trial is when the person is just before a judge only. That's it. No one else. Um, no one else is there, and therefore the parties are relying on the judge to make a decision one way or the other, to make a decision as to who might be liable, who might be guilty, whether someone is not liable, whether someone is acquitted of the charges. Now, in making that choice, there needs to be a lot of soul searching. And what do I mean by that? If you have a bench trial and only the judge is making a decision, you should be confident that the judge, after hearing all the facts as to your case, will rule in your favor versus convincing a jury of 12 or 6, and in a civil case, majority, and in a criminal case, a unanimous decision of the jurors ruling in your favor. Now, we also see this bench trial versus jury trial present itself when it comes down to, at least in New York, it may not be the same in other states, but at least in New York, when it comes down to prosecuting police officers. And the trend has been is that police rely on the judge to make a decision as to their guilt and innocence and as to whether or not they will be found guilty and therefore be incarcerated or whether or not they'll be found innocent. And so in New York, what we see is most officers choosing a bench trial rather than a jury of the peers, which is jury of people in the community that might see it differently than defense counsel wants them to see it. So if you're in Brooklyn, if you're in the Bronx, you know, if something happens where the police are charged, say it's a wrongful death, killing of a civilian, what the police officer, quote, the defendant is betting on that the judge will see his position or her position and how they perceive things, and therefore find them not guilty versus a jury who may have seen stories of this nature throughout their community and don't have a high tolerance level as to whether or not they did their job appropriately and might find them guilty. That's not to say that one is automatic versus the other, but that is the options. And so when we talk about social change and reform, there are people out there that say, well, let's do away with bench trials. Let's let's force a police officer and let's have a uniform system where no matter what, you have the right to a jury trial. Well, then that plays right into the wheels of justice moving slowly because it takes time to have jurors. It might be the fair thing to do, but it takes time to have a jury trial versus a bench trial, which a bench trial can happen over days where there are breaks because
Mm-hmm.
one person is writing notes and one person is presiding over the facts versus a jury trial for which there are no breaks. Now, for those who advocate doing away with the bench trial system, they must understand that if we do away from a bench trial system as it pertains to police, then we're doing away with it forever. You can't have police being tried only by juries, but yet civilians being able to have the option to go bench and jury. So that means there would be jury trials for everyone. Why is that important? That is important because there are some crimes, at least in the state of New York, that if you're charged with, you can have a bench trial. And those are usually B misdemeanors where the the most amount of time that you could spend in jail is 60 days. And so those cases are usually tried by bench, by a judge. So for the advocates out there that say, look, let's do away with bench trials, you must understand that that would be done in a uniform fashion. It's often said it's better to know thy judge than to know the law. And people usually say that in situations where they're trying to find out what is the judge's mindset. Where does the judge lie on certain situations in certain fact scenarios? Does the judge have an opinion that is outside the scope of the law, that is not in agreement with the law? And so, therefore, if you know the judge, you know what buttons you can pull and push, you know what you can say and what you can't say. Well, that same saying holds true for when you have a bench trial versus a jury trial. If you know the judge, then you might say, well, I know this judge either personally or I know how that judge goes about the business, what that judge likes, what that judge has a like for, what that judge has a disdain for. And so, therefore, I want to go bench. That is advantageous to me. And so, that is something I seek. And so, we need to understand that and how that works.
So,
And
so
so,
let's pause for a minute because you said a lot right there with everyone understanding the difference between bench trial and jury trial. But even with the know your judge, what if you're in a situation where you have a public defender and you haven't retained private counsel?
well, I mean, here's the obstacles just in general when you're dealing with a public defender. One is that I always advocate that you should always have a relationship with an attorney, just like you have a relationship with a doctor. You know who your family doctor is. You know you should know who your family attorney is, even though that attorney may not be able to professionally perform for you in every aspect of your life. They may not specialize in elder care. They may only specialize in criminal. They may not specialize in criminal. They only specialize in civil rights. They may not specialize in civil rights, but they only specialize in landlord and tenant. Have some attorney that you at least have a relationship with that you trust. The reason why that's important is because you're trusting that attorney's years of experience, that attorney's wisdom, that attorney's viewpoint as to what might be better in your particular situation, whether it's jury or bench. So that goes to your question. If you have a public defender and you don't have that relationship, then you might be very well trusting a stranger to make that decision for you based upon that stranger's relationship that they may have or experience that they have with being in that courtroom. And I see you put up the steps in a jury trial. This also speaks to what we call the speed of justice, justice moving slowly. So when you have a jury trial, you have to select the jurors, you have to have the trial. I think, and I would submit to you that the judge charges are something that you do whether or not you have a bench trial or a jury trial. But then you have the deliberation where you have to have 6, 12, or a majority of the jurors come to a conclusion one way or the other. Or when they say hung jury, can't come to a conclusion. And therefore, no decision is made. And that may result in what we call a mistrial and then you have to try the case over again. And what is the conclusion? The conclusion is another way of saying the verdict. Now, you can imagine this with a bench trial, there is no selection of a jury. You still have the trial. There may or may not be judge charges because we all know what the facts are pertaining to a particular case. The deliberation is one person making a decision and one person coming to a conclusion, the verdict. You can see how that
Mhm.
is quicker than having a jury trial. But you also can see how dangerous that could be because you are relying on one person to make one decision and see it your way.
And that's something to know, because is there a point where, just for everyone listening, if this comes up, whether it be community, family, somebody you know, what is there a one particular way to say no, you should go always go for a bench trial or go for a jury trial, because you were talking about some of those differences. So I'm just curious, as the audience is learning, what they need to do to measure whether one is better than the other for their circumstance.
Well, one is that definitely there need to be family involvement. And what do I mean by that? As a defendant in a case, either the person being sued, allegedly held liable, or the person that is accused of doing the crime, um, there's a lot that's going on in your brain. There's a lot that you're focusing on at the time that you're before that judge. And so you may not see the nuances that someone who's sitting in the audience would see. How the judge interacts with staff, how what the judge may or may not say after each and every case is over, how a judge treats people that come before him prior to your case, how the judge treats accused who come before him after your case, how the judge treats the attorneys that are standing there waiting for their case to be heard, waiting to represent their clients. All those are indicators, possible indicators, potential indicators of how that judge handles their courtroom and how they go about doing their business. And that is important.
Mhm.
If one shows no tolerance with dealing with people that they deal with all day, every day, then it is likely that with you being a defendant, you being a party in the lawsuit, that there may be little tolerance for you if it's we're talking about a criminal case. You can also get a sense of how the judge thinks by the judge's rulings on certain things, whether or not you can call certain witnesses, whether or not if your client has a curfew and you're trying to get that extended while this case is going on, the judge's position as to whether or not a bond or bail needs to happen, the judge's position as to how long it would take to try a case. You might think a case is going to take 3 weeks to try because you know enough about it. And the judge may say, we're going to try this case next week and we're going to be done in a week. That's an indicator of
Mhm.
what type of justice may come before you. Now, I know judges that have done that and they've done it very efficiently. Tried a case that we thought would take 2 weeks and make it into 1 week. And then I know some judges that have done that and they weren't so careful and thoughtful, and there may have been a miscarriage of justice. Were you going to say something?
Yes, Deborah had a question. She said, when they decide on bench trials, does it affect jury trials and jury duty?
No. So um, one doesn't affect the other. But what it does do is that it will show up in the numbers in reference to how many cases were resolved, how many cases were litigated in Bronx County, how many cases were resolved in Bronx County, how quickly did a judge. So now let me. That's a very good question, right? Because now we're talking about numbers, because there is a number. I don't want to say game, but there is a number issue. So if I'm a judge and I have 185 cases on my docket, if I don't dispose of those cases, the numbers are only going to go up. If I start off with 185, if I don't dispose a certain number of them, I'm going to have 185 plus in 2022. And if I can't dispose of a certain number of cases, I'm going to have 185 plus plus in 2023. So there is some pressure from the administrative judges going down to the judge that may be handling your case to say we have to dispose of these cases. And disposing of the cases can happen in three different ways. In a civil case, it can happen by way of settlement, or it can happen by way of bench or jury trial. Let's get this case going and let's be done with it. In a criminal case, it could be disposed of in two ways. It could be disposed of, let's get a plea, therefore a plea of guilty, and we resolve it, or we have a bench or a jury trial. If we have a bench trial, once again, I control the speed for which the trial is had, and therefore I control how quickly I get through my 185 cases.
Hmm. Good. It definitely good question, as Richard said. And he had a question. He said, "Who determines what judge gets what case?"
Ah, well, this is what we call the wheel. And what do we mean by the wheel? Hold your seats now. I want to make sure you understand this. In the world of technology, in the world of iPhones, Androids, voice control, handless holding of a phone, recording, all these things that you have in technology, the judge gets decided by the old-fashioned bingo way.
Bingo.
Names are in a barrel, and the barrel is rolled round, and the hand is put into the barrel, and the judge comes out.
Wow. Wow. In
Or,
2021?
or, or what happens if we advance the ball a little further? What happens is that they just have a rolling list. So on any given day, a judge is sitting on that list. There was a time and place where people in the federal court system, they will find out what judge is sitting for what particular term, and they would decide that I'm not going to bring my lawsuit that during that term. I'll wait until another judge is sitting in that term, and then I'll bring my lawsuit. What we call
Wow.
forum shopping or cherry picking. You want to forum shop and find out which forum and which judge you want to be in front of, and you want to cherry pick the judge. And so we still haven't found a way to prevent that. And it is my understanding that the old way is the new way and will be the future way in determining who gets what case. Now, there are incidents where you have certain court parts, such as a gun court part or a domestic violence court part or a drug court part, and that's a little bit more deliberate. But when you're talking about a trial and you're talking about whether it's jury or bench, it is arbitrary.
Hmm.
Even when
Well,
you ask that a judge be recused because there may be some conflict, it is still arbitrary.
so that leads us into moving from the judge versus jury trial. And thank you for that explanation. I think definitely helped people understand what it means and what the difference is, because we're watching this play out in real time in the media with a lot of the high profile cases. And it might be something that we're affected by in community with someone that you know. So you just mentioned arbitration. So let's talk about that. I know you're going to get into mediation later, but what is arbitration agreement and what does that mean?
Well, I'm glad that we went to the next subject matter because in kind of in a hierarchical order, we look at jury trials as being the most involved, and then we look at bench trials, next level, where is a judge in a robe, they're making a decision, one person, and then we go to arbitration. Now, arbitration could be a combination of things. Arbitration could be an arbitrator, one person making the decision, or a panel made up of three or five people making a decision. So before we talk about how that is revealed, let's talk about what an arbitration is. An arbitration is an alternative to bringing a lawsuit in the court of law. So what the parties do, they agree to that we're not going to file this in the courthouse. We're not going to spend our money that way where someone has to file a lawsuit and they have to pay and we have to wait for the wheels of justice to move slowly, but they move nonetheless and have to deal with a backlog of cases depending upon what county you're in order to have our dispute resolved. We're going to intentionally choose to arbitrate, and that means we are potentially choosing and we will sign and agree that we will consent to arbitration versus bringing an actual lawsuit in court. That doesn't mean that you don't draft the complaint the same way that you would in court, because an arbitrator or arbitration panel has to read what the lawsuit is about. But you are not selecting a jury. You may not be um, having you may not have one person just decide your case. You may have a panel, but you make that determination when you draft and design the arbitration agreement. So the arbitration agreement is made by the parties. So Dr. Grant and myself, we come and we sign this document that we've made up, that or we drafted, that we said if we have a dispute, we're going to have this dispute resolved by a panel of 3 people. And the reason why you need an odd number is because majority rules, right? You can't have 4 people because 2 people may decide and then you have nothing, no resolution. So we want to have a surefire way that there's resolution. Or we're going to have one arbitrator decide this matter. Not only do you get to decide the number, but within the arbitration agreement, the parties can agree to decide who the arbitrators will be, in that they must both consent to the person or persons that will arbitrate the matter. So that means I might like person A and Dr. Grant might like person B. Therefore, if we don't have total consent, we can't have the arbitration. We both have to decide and agree on the same person or persons to move forward in the arbitration. Something
Now,
else.
before you continue, real quick, so an arbitration potentially could save you money.
Oh, without a question. That's the real reason why people do that. But it doesn't always happen, but it could happen where it saves you tons of money, thousands of dollars. But also it allows you to have control of the matter. So therefore, when you enter an arbitration agreement, you can determine whether you want someone that knows the industry or someone that doesn't know the industry. You may say, well, Mr. Russell, Attorney Russell, I always want somebody that knows the industry. Oh, not so fast, Grasshopper, because if you want someone that's impartial and someone that's bringing a breath of fresh air to the dispute, maybe they don't need to know about the industry. Maybe they need to focus on what the dispute is and how we decide the dispute. But most people want someone from the industry, and usually arbitration panels may consist of one person from the industry, one expert, and one neutral person, what they call a public person. And that's how you get the best of all minds to make a decision and resolve a dispute one way or the other, or get them to settle a dispute. Now, once the arbitrator or the arbitration panel has spoken, depending upon what's in your arbitration agreement, that can be the end of the matter. There may not be available to you an appeal process. Once the arbitrator has spoken, that could be it.
So that's it, and there's no recourse for appeal.
Now, in a criminal, or excuse me, in a jury trial or in a bench trial, there are always levels for appeals. In arbitration, there is none unless it is written somewhere. Now, there's somebody
Oh,
out there saying, and I know this, they're either saying it to themselves while they're in the kitchen or while they're driving in their car or when they hear this show later. No, Mr. Russell, you can always do an Article 78. Well, for those who are so advanced in this area, an Article 78 is not an appeal. What an Article 78 is saying that the arbitrator either ruled in a very arbitrary and capricious way. That means there was no rhyme or rhythm to their decision, or there was something nefarious, or they abused their power and there was something nefarious. There was a relationship that was going on between the parties, and I didn't know about it at the time that the arbitrator ruled or the panel ruled, or the arbitration and the arbitrators decided something that wasn't before them. The dispute was about A and B. The arbitrator decided not only A and B, they decided E, F, and G. But that is not necessarily an appeal. That is a review because you have violated some tenets of your power. So the ruling
mm,
may still stand.
interesting.
And that
Well,
is very much a tricky situation.
But it also speaks to having the proper counsel and having things written properly or in a way that if you need that, that you're protected.
That is definitely true. One other thing in
Mm-hmm.
arbitration versus bench or jury trial is that in New York City, in many states, this is not only quantified and only refers to New York City, but in many states, what happens is that you have rules of law that you must abide by. Hearsay rule, credibility, whether you could bring in someone's prior bad acts. All these rules apply when you're having a jury and a bench trial. Well, in arbitration, those rules of evidence, those code of conducts, supposed to be relaxed or can be flexible. That means an arbitrator can listen to hearsay. The arbitration panel can listen to prior bad acts without there being any ruling that says that you can't. There's a lot of leeway and flexibility for the arbitrator or the arbitration panel to hear a variety of pieces of evidence that may not make its way into the courtroom because of the rule of evidence that exists
Interesting.
in the courtroom.
Well, we definitely learned something additional if you didn't know about the difference. And then let's wind it up with mediation. So, how do we get here?
So now mediation, I don't want to say, I don't want to speak in hierarchy as far as the lowest level, but it's the most friendliest level. So what mediation is basically saying is that we have a problem and I don't want to sue you and I don't really want to deal with an arbitrator, but I still have those avenues available to me to do it if I need to do it. But first, let's try mediation. It's almost as if you're a caretaker and you say, before we get to corporal punishment, let's try a timeout. Let's just take a timeout. So mediation is what I call a timeout. And
Mm,
what happens in mediation? Mediation is really about resolving the issues at hand in the most amicable, friendly environment. There is no rules of evidence. Every and anything can be considered and can be said, but it's all done in good faith of having the parties make a decision on how they want to resolve a dispute. And
mm,
the parties can fashion what the resolution is. And the mediator, and it's usually one person, is the conduit, is the liaison, the vehicle of bringing two parties together for resolution.
mm. And
And
this is
that's the,
without the
and that's the
court.
tricky part. That's the tricky part because unlike any other venue, when you're doing a bench and a jury trial, you're told to leave your emotions outside. When you're dealing with an arbitration panel, you're advised to leave your emotions outside. But in mediation, the mediator probably wants you to bring everything to the table because it has been my experience as a mediator and as an arbitrator, but definitely as a mediator, that the dispute may not be really what is at odds and what is at issue. The dispute is what brings us to the table, but there might be some underlying issues that is also present that makes its way to the surface when we have this dispute and when we're talking about this dispute. That might be one of lack of respect, lack of consideration, how business is done, and how business should be done in the future. So a mediator brings the parties together and kind of tries to resolve the conflict in the best way they can,
Mhm,
bringing closure, as Kevin just said, without
mhm.
going through the heartaches of filing certain claims. And if you could read what Kevin's comment was in total,
Yeah,
there's
sure.
something he said to that.
I'll share. It says mediation is forward thinking way to resolve conflicts, knowing that there's value in closure.
Right. And so I want to underline forward thinking. So that means anything is possible. Everything is possible. There's nothing that is on the table that you will not consider to bring in closure. There's nothing that you will not avail yourself to in order to move on. Now, mediation is very hard to participate in and be successful in if people have identity crisis. That means that they identify, and the only way they see themselves is through the conflict, versus someone that can say, this is a conflict, this is not my identity, let me resolve this so I can move on and do something else. And
Right.
so that is where you get the most out of mediation, being able to be more personable, being able to break down what are the real issues. And in mediation and in arbitration, we have what we call breakout rooms, where after the parties have put on the table what the dispute is, and I will tell you right now, arbitration, bench and jury trials are more adversarial, have the air of hostility, has the
Hmm.
air of I'm going to prove you wrong, versus mediation, which has the air of I want to hear you out. Let
Right.
me hear what you have to say. Let the other party hear what you have to say. And then let's caucus. I'm talking to you. You're talking to me. I get a sense of what's important. I put that in the piggy bank. I go to the other side. I talk to them. They talk to me. They tell me what's important. I put that in the piggy bank. Then I shake the piggy bank. I crack the piggy bank and I find the synergies. I find that I have two nickels and I have two dimes, and maybe I have a Canadian coin and maybe I have a Jamaican coin or a slug, but I have these two nickels and I have these two dimes, and that's the common ground. And so I'm gonna take these two nickels and I'm gonna take these two dimes, and so that's 20 right there, and that's 25, and that's 30, and I'm gonna take the 30 cents and put it together, and we're gonna resolve this. And sometimes you can
Absolutely.
only do that in a caucus where you're separated from the noise. And I have time to speak to you and I have time to massage what I think the other person is saying. It's quite similar to going to therapy on a legal realm, if I can say.
Well, I think that Kevin also agreed, as he said, breakout rooms or caucus is an important, part of the process as well, to do just what you said, give people a chance to look at what's really important, what do I really need to happen as closure, and what's really important, because I think it forces you to put that all into perspective when you have a good mediator who's able to help the emotions come out but not get in the way of resolution. So
And let me add to what you're saying. This is where trust, real trust,
mhm,
is displayed. So a judge, the person that is accused, or the person that is accused of being liable, or the person is accused of committing a crime, they don't get a chance to get a sense of who the judge really is. They don't get a chance to touch and feel the judge. In arbitration, you really don't get a chance to touch and feel the arbitrator. There is this still reverence for, we are the authority, you give us the dispute and we would make a decision, versus mediation. The mediator may be the authority, but not necessarily the authority in the industry, but the authority in having people see the error of their ways, having people understand that you really need to move beyond this. We really need to think outside of the box and how to resolve it. And that takes trust. So a mediator has the ground, has the room to talk about things that may not even be in line with the mediation, to develop a rapport, to have the parties trust them in their judgment and what how they're going to go about mediating, so there can be a resolution. And that doesn't mean that the mediation happens in one hour, 2 hours, 3 hours, or one day. It may take a couple of days for it to all pan itself out.
but
But
it's a process.
it is a process and it's far less costly than
Mhm.
going into court. You're not you're not paying any fees for the docket. You might be paying an hourly, or you will be paying an hourly for the mediator. But once
Mhm.
again, the parties will determine that, right?
Right.
We only gonna do this one time for 4 hours, and if we can't resolve it, then that's that. But those are the things that come to the forefront.
Well, thank you for taking the time to explain that so we can see what's happening not only in current events, but how we can be knowledgeable that if the event arises that you or family member, community member needs to make a decision or know what direction to go in, first start with having an attorney that you have a relationship with, as you said. So we have two legal experts here on the show, and they can contact you at law office contact Ed at law office of edpichardo.com or roycerussellesquire.com. Two easy ways to build a relationship with an attorney. And then you can start to understand whether, depending on what kind of case it is, if a jury trial, bench trial, arbitration, or mediation is something that can be a benefit to you. So great content today. Thank you so much, Mr. Russell. We're coming down to wrapping up a hearty discussion, and we want to thank all of those who have participated. And Kevin said he was at the EEOC and he was paid a flat fee. So this is your lane, Kevin, as well. So we
Yeah, and
appreciate your.
Kevin makes a great point. There are some agencies out there where the mediator gets a flat fee for the day, so then there is no pressure, and that's the key in mediation. I'm glad he brought that up. The ability for there to not to be pressure.
Mm-hmm.
Resolution without pressure sometimes gets great resolve, and so
Absolutely.
that's the air that we want to bring, and that's the breeze that's coming through the window. And so as we look at COVID and what the pandemic has done and how things are shifting on the criminal side, mediation is obviously not an issue, but the bench trial, jury trial is still becoming very vibrant in reform. On the civil, you're starting to see more arbitration and more mediation. And that for those out there who have expertise, like Kevin and others, we mention these things with the cultural side. And here's the cultural side, that if you want to be an arbitrator, if you want to be a mediator, now's the time to start building up your CV, your curricula de vitae, build it up, build up the resume so you can serve as an expert in a mediator or arbitrator, because people are now choosing to resolve matters outside of courtrooms, and you do not need to be an attorney to fulfill those positions. You just need to be a either one that is very reasonable and know how to have parties come together and agree, or be an expert in that area.
And that's a great point to share, especially in a time when people are looking for employment and resources, that is an option. So we always have information that you can use. We give you content that is applicable, obviously, where the legal meets the cultural, as well as what's happening in real time. So today was one of our educational sessions. And Mr. Russell, thank you so much for breaking down those four different areas for us to understand and be armed with. So we're going to wrap up for today. Any final thoughts?
Well, I would hope that those that have heard this session replay it, take the notes, because when those decisions come upon you, you want to be able to have a reflective point to go to. And this is one of those segments that you need to earmark, because you are trying to propel yourself as far as having information, being educated, being empowered so you can execute. And so today is one of those days.
All right. So, everyone, thank you again, Mr. Russell, and everyone tune in. We'll be back next week, 4 p.m. Eastern Standard Time, for another episode of Speaking Legally, where the legal meets the cultural. Thank you so much, Kevin and Richard and Deborah and everyone who's been a part of our show today. We thank you. For those who'll be watching the replay, put hashtag replay, and we'll be back again soon. Bye for now.
Take care, everybody.